614 Startups Nation, welcome back to Ask an Expert. Today I have our legal contributor, Demetrius Robinson of KJK, with us to discuss the top legal mistakes startup founders make. We're on to legal mistake number 2, and that's around organizational structure and corporate structure. Demetrius, break it down for us.
Hey, Elio. Thanks for having me again. Happy to talk about some of the things I've seen in my practice and working with founders before. So mistake number 2, right, is operational structure, corporate considerations. The reason I phrase it like that is because it's kind of one of the first decisions that founders need to make about who they want to be when they grow up, right? And it's a pretty, it could be what's considered an easy mistake to make. One, because sometimes things are flashy. And so we choose, a certain structure because, we talked to our best friend and he said, hey, yeah, you got to be a such and such because that's what everyone's doing on the West Coast. But that structure may not make sense for your business or for where you want to be or the kind of organization that you're tending to operate. And so definitely don't get sort of drawn in by sort of what everyone else is doing because it may not make sense. So what do we mean when we talk about organizational structure? What we mean is that in the United States and most states, you can be sort of 3 common entities. You can be a limited liability company, you can be a corporation, you can be a partnership, and each of those sort of has some variations of themselves, especially in the partnership realm. And each of them sort of have different legal requirements as it relates to who they are, right? So a partnership, you need at least 2 people to be a partnership, makes sense, right? The other ones, you can be, a single individual that has chosen to be an LLC or a corporation. It's just kind of your entity created its own persona of who you are. But each of those kind of have different requirements, right? So LLCs, corporations, partnerships, you still need the same organizational documents. They're a little different, but there's different laws that apply to each of them. And more importantly, obviously, as a tax professional, there's different tax implications to each of those structures, right? So an LLC can be taxed either as what's called a disregarded entity, which means it's a flow through. Usually, it's one person, and your sort of tax, whatever the business does, then gets translated into your personal income tax return. Corporations generally sort of are taxed at the corporate level, 21% currently right now. At the federal level, though, there's other applications, state and local sometimes. But it can make some elections to be treated differently. Then a partnership is usually taxed as a partnership for U.S. tax purposes at the federal level. Again, unless you've made some sort of election to be taxed differently than that traditional model. And so those are just all sort of implications of each of them. No organizational structure is incorrect per se. I would say the only incorrect structure is not to have a structure. You can be what's called a sole proprietor, in which you sort of just put yourself out there to do business as yourself. That is a model, but not something I think most legal professionals would recommend, just because you're not necessarily getting the same level of protections you would get in other spaces if you were an actual legal entity separate up from its owner. So yeah, I mean, just something to think about from the organizational structure perspective. As it relates to corporate governance mistakes is because you are a separate legal entity from yourself, sort of courts and sort of general, laws sort of highly encourage that you maintain sort of proper governance documents that articulate that I am actually, doing what I'm supposed to do as a legal entity. And so usually that means, if I'm a corporation, even sometimes as an LLC, if I want to be sort of a board structure, that means I'm taking board minutes, meeting minutes. I'm sort of signing those resolutions to say, hey, this is what we did. We're approving the ability to do X, Y, and Z, whether it's buying something to the company, or we're authorizing our president, vice president to do X, Y, and Z, and or we're appointing those individuals to fill those seats, and then those are the roles that they're intending to be So you want to make sure you do that. One, because there's some concerns that if you don't do that and then you're sued, a court might try to do what's called piercing the corporate veil, and that means that it's disregarding that you have a legal entity and it's trying to go directly at you. And if you have not taken those steps to sort of create the actual legal entity and maintain it, then that is a risk that you run. The other thing is, as it relates to corporate governance, is maintaining the documents that you do create. So you're going to sign agreements with third parties, whether it's service agreements, whether it's other contracts or anything like that. Keep records of those, because one, there may be opportunities in the future to revise them, right? So maybe you saw something in there that you liked or didn't like, and there'll be times to negotiate that, and you want to be able to refer back to, well, what did I didn't like in that agreement, or what did I like that I want to keep, or I want to use in a different agreement, right? The other is you're going to potentially have employees. You want to maintain that so that if there is any issues related to those individuals, you can point back to that agreement that says, hey, you agreed at the very beginning of our relationship that you would do X, Y, and Z. Unfortunately, you have not done X, Y, and Z, or you agreed that this is going to be an at-will employment, and so unfortunately, I'm terminating your services because they're no longer needed. Those sort of things, you want to know that, so you want to maintain them in some sort of way so that they're readily acceptable. In addition to potential risks of litigation, right? Something to point to if that situation does arise. And the other one is sort of equity awards, right? You're going to put together some sort of cap table that says, hey, I have 1,000 shares. I'm allocating X number of shares to the founders, and then maybe my employees get X number of shares. Well, if you've over allocated and you've only been authorized by the state to issue 1,000 shares, and you over allocate to 12,000 shares, well, then you got to go back to the state and ask for more shares. Not usually a significant issue, but can arise, and you want to avoid that simple mistake just because you didn't properly keep track of the number of shares that you issued, especially if you're using something like a stock option award, where you're not actually issuing those shares right away, you're potentially issuing them later. So you want to keep track that those may be allocated, even if they're not currently allocated. So that's something to think about as it relates to sort of maintaining those documents. The other is probably even more important is maintaining proper HR documents, right? So you're going to put together some sort of employee handbook that's going to articulate to your employees, here's my expectations of the organization. Here's how I want you to operate. If there's issues, go to HR. You can't, do X, Y, and Z, whether it's talk to people a certain way or discriminate against a certain class of individuals. You're going to articulate all that so everyone knows right up front, their expectations. And sometimes it's, hey, this is where everyone gets paid every 2 weeks, right? You can put that in your, your employee handbook. So everyone knows, hey, my paycheck's going to be on the 1st and the 15th, and I know it's there. So, and then, for performance reviews and disciplinary actions, you're going to document those things because eventually, if you need to terminate an employee, you're going to have a record that you can point to that says, hey, I'm not terminating you for an issue that may be related to a protection under law. Is because your performance or lack of performance is the reason I'm terminating your services. And so if litigation arises, you can point to it's not because they were a certain race or religion or something like that. It's solely because they didn't perform, and here's the documentation supporting that. So yeah, those are sort of simple things to consider to avoid, making mistake number 2.
Yeah, there you have it, folks. Demetrius, thank you so much for the insights. As usual, you provide a lot of value, you give a lot of perspective, and all of it is practical and applicable when you are building a company. Folks, if you have a specific question, like, hey, which corporate structure is best for raising capital? I know that's what's on your mind. Reach out to my guy, Demetrius Robinson, over at KJK. And stay tuned as we continue to answer all your questions on Ask an Expert. That's a wrap, folks. You can find this and all our episodes on our website, 614startups.com, Apple Podcasts, Spotify, Anchor, and all your favorite podcasting platforms. Don't forget to subscribe and write a review. If you'd like updates sent directly to your inbox, you can sign up for our weekly newsletter on the website. To engage in the 614 Startups community, follow us on LinkedIn, Twitter, Facebook, and Instagram at 614 Startups on all platforms and join the conversation. For sponsorship opportunities and collaborations, email us at info@614startups.com.